We are going to move on to another attorney, Ms. Micha Star Liberty, who's going to talk about sexual abuse of students, I believe in particular special ed students.
Good afternoon, everyone. I'm Micha Star Liberty. I'm a civil attorney, and I practice law all over the state of California. I do financial abuse cases, I do physical abuse cases, and sadly, I do a lot more sexual abuse cases than I would like to see come through our office doors. When special education students are sexually assaulted on campus. And I want to, before I get into it, take a step back and say a lot of times when we have special education on special education sex abuse cases, the focus is on who had the legal duty to protect both of these students. And the answer is the school district. So common law, for those non-lawyers out there, is court-created law. And for almost 45 years in the state of California, it has been the law that school districts have the duty to supervise students while they're on school grounds. This is a non-delegable duty, meaning they can't pass the buck. It's no one else's responsibility to make sure these students, particularly special education students, have appropriate supervision. There's also a duty to protect the students. And why is that? We send our kids to school and we assume they're going to be safe while they're on campus, right? So it was 1986 when the courts first said, yes, there's a non-delegable duty because of the special relationship, that trust that we have for our school districts when we send our kids to school. That's why the focus is on the school. There are also statutory duties. So statutes are laws created by the legislature, right? So it's part of a deliberative process. There are committee hearings. There are folks who go up and lobby one way or another. The California Code of Regulations says that principals have the necessary power to make sure that folks are protected and supervised.
California has over 40 years of case law regarding sexual abuse against students. In 1986, it became statutory law implemented through the California Code of Regulations, which gives school principals authority over these issues. It is also now part of the California Constitution, Article 1, Section 28A. In 1986, a new child abuse law was enacted. California Penal Code 1347 states in pertinent part, quote, may order that the testimony of a minor 13 years of age or younger at the time of the motion be taken by contemporaneous examination and cross-examination in another place and out of the presence of the judge, jury, defendant, or defendants, and attorneys, and communicated to the courtroom by means of closed-circuit television, end quote.
And this is one of the few statutes or constitutions where we see protection for young people, right? Children don't have a lot of rights always, but we've got this in our California Constitution, which I think is a good thing and fantastic. Now, so we've covered the duties, right, what the school districts are required to do. These are examples from cases I have in my office right now of special education, on special education, sex abuse cases. Every single day I see situations where students who've been abused are denied medical attention. Their police are not called in right away. Investigations are done in such an inept manner because there's no training on how to do them that very necessary evidence is destroyed, statements are lost, folks who, witnesses are not, their information is not recorded down, and you see these things over and over and over again. And the one that I really want to kind of talk about, because I've seen this too many times, is the failure to make sure that every area on campus is able to be supervised. We see a lot of sexual assaults in bathrooms. We see a lot of sexual assaults in locker rooms, in elevators on campus, in areas on a playground which are not easily observable. I've had so many cases in the East Bay with school districts where someone cut a hole in the fence somewhere, and they would take perpetrators would take victims kind of a little bit behind something because they've dug through something. Kids are always kind of playing and probably trying to hide, but it's the district's responsibility to make sure if there are those areas that aren't easily observable, that there's nothing really serious going on. So the other area I want to talk about really quickly that I see in every single case is a failure to train people who are required to supervise. That's really what this comes down to. People who work in schools do it because they love it. They're not doing it because it's a glamorous and lucrative way to make a living. They're doing it because they really care about children and want to be involved in educating them. Their job is not to ferret out whether abuse is occurring. Their job is not to prevent sexual assault while on campus. At least that's not what they believe. But it's the district's job to ensure that they're trained so they can identify it when it happens and they can react to it when it happens safely and appropriately. Because what we see time and time again is two special education students, one victimizes the other, and they get put back into the same classroom for the rest of the day. How traumatizing is that, to be put back in the classroom with your abuser? Because they just don't know. They don't know. That's really what it comes down to. They just don't know what their obligations are. I have to say that every single case that I have, I ask in deposition or at trial, and I have someone on the stand, I ask them if they're a mandatory reporter, and they all say yes. And then I ask them to explain to me what that means, and 9 out of 10 can't. They don't really understand what that truly means. And their impression is, once someone else knows, I'm good. I don't have anything else that I need to do because the principal knows or the teacher knows, but that's not really what their obligation is. So the problems that we just had that laundry list of failures, unfortunate failures, but they really come from a couple of root problems. One is policies are not drafted appropriately. They're not drafted properly. They don't always comport with the state of the law. And even when we do see good policies, which is in some cases, we see folks who are not trained on what those policies are. Well, yes, the certified people have that, or the administrators have that kind of a policy. Or I hear all the time, well, we train supervisors on sexual harassment. Well, that's not really what we're talking about. Peer-on-peer sexual harassment is very, very different than student-on-student abuse. And they just don't get the difference. And then the other area that I see a lot is kind of a failure for the folks to identify their own biases, right? I hear all the time, children will experiment. Special education students have challenges in terms of impulse control. I hear a lot of things that are, I think, biases that people kind of take a step back and throw their hands up and say, well, this stuff happens. We can't always stop it. And maybe that's true, but you see traditionally several occurrences of abuse that escalate to something very serious. And then they're still taking the position, well, we couldn't have done anything, or this is a natural part of adolescence. Or the thing that kills me every time I hear it is, it was probably consensual. And we hear that all the time. So one of the things that I do when I represent families, and I really look at it like I'm representing the family, yes, the student, the victim, is the plaintiff, that's what we call it in civil law, but this is a family issue. Family needs to figure out how to help the victim. Family needs to figure out strategies for making sure this doesn't happen again. Because what we see when we work with our psychological and medical experts is once there's a event, the victimization cycle can, without training, education, and therapy, continue on. So what we do is we talk about what it means to engage in litigation. And one of the things y'all need to be cognizant of is the timelines associated with litigation. Normal cases where someone's hurt, it's a 2-year statute of limitations. A statute of limitations is a hard and fast deadline, meaning you miss this, you can't bring a claim. But when you're suing a governmental entity, it's 6 months. 6 months to bring a claim against the entity. They have the opportunity to say, oh yes, we're so sorry, let us enter a negotiation and pay you. I've been doing this a long time. I've never had a governmental entity offer to write a check. So what they do is deny it, and then you've got another 6 months before you have to bring that lawsuit. So if you're unwary about the timelines, or you go to a lawyer who's not used to suing governmental entities, you could be in trouble, and your rights will be forever waived. There's really not much you can do. The other thing we like to do is analyze culpable parties. Who's responsible? And like I said in the beginning, our office rarely brings the perpetrator in. If we have an adult teacher with a student, sometimes we do. But again, usually the focus is on the systemic failings that led to this happening, because that's where the power is. These are, we pay our taxes to ensure that these governmental entities are following the law and protecting the people that are there. So that's our focus, on having them change their policies and procedures so this doesn't happen again the next time. And then the other thing we do is analyze the damages. And this is tricky, particularly when we have special needs students who have impairments, may not be able to articulate exactly what the sexual abuse, how it impacted them, because of whatever else is going on. And that's something I have to say shamefully that the defendants try to take advantage of. I've had lawyers say to me, your kid can't really talk about how this harmed them. So did it? How do you put a dollar amount on that? They can't even explain. They're still friends with their perpetrator. How can you ask us to pay money to compensate them? And it's a challenge. We have to rely on experts. And of course, we all know, of course they were harmed. Of course they were harmed. Just because they don't have the language to explain it, of course they were harmed. That's one of the, kind of moving over to the other side of the slide, that's one of the common defenses that we see. And it can be a challenge in front of a jury. And then the other challenge that we have in front of juries is juries understand that these are taxpayer dollars. And teachers work hard, and they're underpaid, and schools are always up against, these financial burdens. And do we really want to spend taxpayer dollars in this way? It's one of those biases we have to overcome in these types of cases. They're not easy, certainly, but I think they're important. So I kind of rushed through this because I wanted to be mindful of everyone's time. I'm happy to answer any questions that anyone may have. Yes, ma'am.
What is the website?
My website?
Yes.
libertylaw.com. You're welcome.
So we're mostly talking about student-on-student perpetration of sexual assault, sexual violence. Is that right?
We do all kinds of cases. This particular topic is so nuanced that it was interesting to me. That's why I'm kind of focusing on special ed.
Yeah, okay. And are there usually ever any criminal charges that are brought against someone who may be a student also who is sexually assaulting their classmate?
Yeah, it depends on the facts. I just resolved a case a couple of weeks ago where the perpetrator was on probation for sexually assaulting a 10-year-old at the time that he raped one of his classmates. He was 18 at the time because, I think you can go until 22 when you're a special ed student. So he was an adult, and the victim was under the age of 14. So the DA did get involved in that, and that perpetrator, who we did not sue, I think did 2 years in Santa Rita, and he now has his special education teachings at home, and the district is paying for counseling for the perpetrator to kind of help him work through these issues. It's very sticky, right, because this is someone he was abused himself in Mexico before he immigrated here. He acted out a pattern that was familiar. He had a criminal history. The school didn't react to that, and then it happened again. So sometimes it does. The other thing I want to mention just quickly, because it just popped into my head, this is something that I find a little frustrating. What the schools tend to do is focus on discipline. So there's the policies are really all built around how do we punish this the bad actor, rather than how do we help the victim, how do we help the perpetrator, how do we identify and train people appropriately so this doesn't happen again. So it's a real punitive structure. And so when they're special education students who are the perps, they have to go through what's called a manifestation determination hearing before they can be disciplined. And what I've seen more often than not is when they go through the manifestation determination, because the district doesn't really want to get involved, even though there are psychologists and psychiatrists and therapists and the special ed teachers involved in this determination, usually what they do is kind of throw their hands up and say, yes, it was a manifestation of the autism or whatever it is. Which, I think that it would be nice to see more of a holistic approach rather than focus on discipline. And they kind of punt, to be totally candid, when it comes to this manifestation determination. Yes, sir?
Does the perpetrator have to go through the criminal law process first for you to have a successful civil case against him?
No. It's not that it's apples and oranges, but the perpetrator's conduct is relevant to the extent that it happened. So it happened, and then we say it's the district's responsibility to have prevented it. If they were protecting the student, it wouldn't have happened. If they were supervising the perpetrator, it wouldn't have happened. And in civil law, and this might be a little too wonky and technical, but we would actually have to trail a criminal case. So sometimes the criminal piece can get in the way of a civil matter, but we deal with it. Yes, ma'am.
Madam Chair, although my daughter's is 7, she went through a similar thing in kindergarten, where there was another child actually sexually abusing and grabbing her, and they did bring in the psychologist, and she's in counseling now. But you did answer a lot of questions for me that I'm going to be aware of, and I didn't know that 6 months law, and I can see how aggressive they were to make me please within that 6 months. But I'm going to be very aware of what you're saying today for when she goes back to school, because they did keep her in the same class with that child. Mm-hmm. And my daughter still struggles with this little boy, and they're little. So
right.
Thank you for the information.
You're welcome. It's really a challenge. I'll just add, I have a case right now where a young girl who was 7 at the time was pinned down by 3 boys. So 2 held her down, and then they took turns sexually assaulting her. And she couldn't process it because of her age. And so now what we're starting to see, the statute of limitations is a real bear, because it takes a while for this trauma to manifest, particularly when you're talking about folks with special needs or someone so young. But the key really is finding a good therapist and helping her work through the loss of power, or the sense of loss of power.
A lot of that myself, so I've been teaching her when I teach adults. I've been teaching her at her level, plus she's in counseling, but she's still got that. I'm going to be more alert.
Yeah, good for you. Are there any other questions? Yes, sir.
Would the recent cases against UC for not responding to allegations of rape, would those cases, if they actually reach case law, help your arguments?
Those, you're talking about the new statute that's come out, or that is proposed?
We're not talking about disabled individuals, but there's still the institutional behavior or lack of behavior. Could you pull that argument into your argument?
I think it probably depends on the cognitive level of the victim. So for those of you who don't know, there are statutes that are being proposed now. It's in the Senate, and I can't think of the number, but it's a yes means yes rule on college campuses rather than no means no. So what the proposal is now, you need to get an affirmative yes before you have sex with someone. So I think the issue would be, when you're talking about minors, the reality is the law says they can't consent. They can't legally consent. So I don't know, but there might be some way eventually down the road. It'll be interesting to see how the case law kind of plays out.